Hello and welcome to Holland Estates. I am Stuart Clark.
And I'm Domratchev.
And I have no idea what number podcast this is because, as you can maybe tell from the fact that we're doing this on Zoom right now, we are doing this from our homes because we are still in COVID times. So in the post-apocalyptic COVID times, we don't need no stinking podcast number, although maybe a podcast number will be added to it at some point in the future by someone sometime. But hello, welcome to our home podcast. This is the first for me. This is the first Zoom-based podcast for me. I think as well, right, Kira?
Yep.
So we'll cross our fingers and hope for the best, and hopefully this all works. But hello to anyone out there listening. I hope you're staying safe and staying healthy and doing what you can during these strange, uncertain times. But we have a podcast for you. So if you are in the mood for some estate litigation-based podcasting, well, you're in the right spot today. And we have an interesting case, which is the case called Deleon versus the Estate of Raymon DeRanney. I hope I'm saying that correctly, which is a relatively recent case from Ontario from Justice Dietrich, which deals with a scenario of someone who is not a biological child, but who wants to be, or who claims that they are a dependent of the deceased estate looking for money. So Kira, maybe you can give us a bit of the background.
All right. So the deceased Raymon DeRanney died on December 26, 2017. It was a sudden death. There was no will. He actually died of a heart attack, I believe, while he was on vacation. So really quite sad. It was not expected by anyone. He did not leave a will, as I mentioned. He had two surviving siblings, one biological child, Sonia DeRanney, and then there were the applicants. So it wasn't entirely clear what the relationship was between the deceased and the applicants for the reasons to follow. So Fritzi Deleon and her daughter, Casey Lynn Deleon, had some sort of a relationship with the deceased, and the court sort of had to decide upon that. Fritzi and the deceased at one point were in a relationship, so I believe they dated between 1993 and 1999. Then they broke up, and Fritzi had Casey Lynn. But then the deceased sort of remained friendly with them, and at some point he essentially moved both of them into their residence. So at a certain point, he lived in the house with his biological daughter, Sonia, as well as Fritzi and Casey Lynn. Casey Lynn essentially lived in that residence between 2001 to 2016, which is so important because it's 15 years of her life. And I think that when the application was commenced, she was almost 18 or sort of nearing the age of majority. And there were periods of time when both the deceased and Fritzi, Casey Lynn's mom, were in relationships with other people. They spent time not living at the house, but Casey Lynn spent those 15 years essentially living in the house. So she was providing that since she didn't pay rent, nothing like that. Then at some point in 2017, the property was sold and the deceased decided that Casey Lynn was better off living with her mom. And so he rented a place for them, sublet it to them for lower than market rate, and then just paid the difference. But it was really not the whole amount. Like, he wasn't paying rent entirely. He also paid for her extracurriculars. Like, at some point he got her a puppy, and he paid for the vet bills and for the food. They took a few vacations together, but they weren't entirely integrated. So it was like kind of just a different arrangement here. And so when he died, his estate was worth about $1.5 million. And interestingly, I see that Royal Trust was appointed as the estate trustee. So I wonder if that was just done from the get-go because of this proceeding. And so when he died, Fritzi and Casey Lynn commenced a dependent support application against his estate. Fritzi actually withdrew her application about a year or so into it, but Casey Lynn's applications moved forward. And so the court essentially had to decide whether there is any support for this adult dependent child.
Mm-hmm.
Casey Lynn.
No, and as Kira kind of mentioned before, that in this scenario, the deceased died without a will, but had one biological child at the time of his death. So, Royal Trust, as a estate trustee under normal circumstances, would send the entirety of the estate over the surviving daughter. But obviously, Casey Lynn, the child who claimed that she was had a settled intention to be treated as a child who lived with the deceased throughout most of her lifetime, would under normal circumstances get nothing. So she is bringing forward a claim saying, I'm a dependent. Now, in Ontario, dependent support applications are brought under Part 5 of the Session Law Reform Act. And under that, kind of broad heading, people who can be included as a dependent include a child. And then child itself is then further broken down to, include people, like biological children or adoptive children, but also people who the deceased had a settled intention to treat as a child. Now, under most circumstances, that would be, stepchildren or something like that. But in this circumstance, Casey Lynn is basically saying, look, the deceased here had a settled intention to treat me as a child, even though I was not his biological child, and even though my mother was not in a relationship with the deceased at the time of his death, and for several years, decades prior to his death, the fact that he let me live with him and paid for things like my extracurricular activities, vacations, groceries, rent, et cetera, shows that he had a settled intention to treat me as a child. So Justice Dietrich has the task of deciding, is this person a child for the purposes of the statute? So, and she, in reviewing the case law, she cites to a 2015 case called Hyatt and Ralph, which sets out the test for what you're to look for in whether or not someone had a settled intention to treat you as a child. And there are questions like, did the parents pool their income into a joint account? Did the parents pay the expenses for all children out of the same account? Did the child in question refer to the man as daddy or the woman as mummy? Did the parents refer to themselves as mummy and daddy? Did the parents share the task of disciplining the child? Did the child participate in the extended family in the same way as a biological child would? Did the child have a relationship with the biological parent? Was there a change of surname? Was there a discussion of adoption? Was the parent engaging in decisions about education and attending parent-teacher meetings? So here, interestingly enough, Justice Dietrich says this circumstance doesn't meet that test. If you go through that test as a matter of fact, this circumstance is not one that would meet that kind of classic test for a child when they're not actually a biological child, like a stepchild. But even though she found that, she said this circumstance, because the deceased let her live with him for so long and put a roof over her head for decades plus, and paid for her food and paid for her pet and paid for her vacations, that she's still going to find this circumstance one in which the deceased had treated the person as a child, and therefore she could get support from his estate.
Yeah, I think that the shelter issue was really seen by Justice Dietrich as one of importance, because there was another case that she distinguished from where somebody paid for like an ex-girlfriend and her kid, but the kid didn't live with them, and there was no I think payment for shelter. And so she really emphasized the fact that she lived with him for portions of her life, and she consistently lived in a house that he paid for. So he paid for essentially for all accommodations, any bills associated with it. And I think that what's interesting, and I'm actually quite happy to see something like this, is because these factors that, Stuart, you just reviewed, they sort of presume a very standard understanding of what a family is. And I mean, that is not necessarily the case today. And it's just good to see that a judge will sit down and actually look at the circumstances and see what these particular facts mean for this particular person, even if these, factors that have been determined to be relevant are not necessarily met.
Mm-hmm. So in this instance, as I said, Justice Dietrich says, yes, you are a dependent. I find that you are a child of the deceased for the purposes of the dependent support application, and therefore you're entitled to support. So of course, the next question is quantum, how much you get, right? So Kira mentioned before that it's a 1.5 million approximate estate here. So, a fairly sizable estate. Only one other beneficiary normally, right? The single biological daughter would get everything on the intestacy. So has now been found to be a child of deceased. So her starting position is, well, I want half. If there are now two children of the deceased for the purposes of the statute, I think I should get half of the estate. And Justice Dietrich, runs through all the case law, talks about moral support, tattering, et cetera, and says, you know what? No, I mean, yes, I found that your relationship with the deceased was one of parent-child akin to, but the ways he was supporting you before death were not raise the expectation to the point where you should get half of this $1.5 million estate. Basically, at that point, she had just turned 18, or I think when he died, or was about to turn 18. She had just started attending university, and he had expressed an intention to help support her through university. But at that point, he was only subsidizing her life to the tune of about $500 a month in rent. And Justice Dietrich said, you know what? All things considered, looking at this package deal, I'm going to give you money to get through university, but that's basically it. So she awarded her, I think it was about $40,000 in support as a lump sum payment to get her through university. And that's it. So she's not getting half of the estate here. She's only getting, relatively modest $40,000 to get through university.
Yeah. And Justice Dietrich also found it relevant that the deceased was nearing retirement, so he started making arrangements for that. There were some documents that were part of the court record showing that he clearly treated his biological child differently in that, he, I think, gave her a condo essentially. He put her on an RSP account. And when asked by the financial advisor that he met in preparation for retirement whether he had any dependents otherwise, he said no, and he made no arrangements for her. And the circumstances were changing a little bit, especially if he was going to retire. He was not going to and he was not going to support her as much, and that was seen from the way that he was no longer essentially paying for her shelter. So
No, but a really interesting case. As this case does a great job, as Kira mentioned, showing that these kind of modern family structures that we're seeing more and more commonly here. And in the decision here, that the Justice Dietrich even gets into the idea of co-parenting. Were they co-parents? And the quickly shifting traditional definitions of what a family is. And even in those circumstances, that the case law allows children, quote unquote, who may not be biological children, but somehow fit into the new structure, to have the rights to seek dependent support after death, which is a great step forward. This case does a great job at kind of summarizing the law on point. But in this instance, even though the person was found to be a dependent, $40,000 isn't nothing, but it's certainly not half of a $1.5 million estate that I think she probably thought she was getting.
And particularly given that, this application had to be commenced, so there's probably costs involved as well. So
very much
it's really not a significant award, taking into account all of that.
No, for sure. No, it's the decision I've seen, the costs hadn't been determined yet, but I know Justice Dietrich said she was going to take into account the fact that the mother had abandoned her application, I think shortly after mediation, when it became clear that she wasn't going to meet the common law spouse threshold. But obviously, her daughter here was eventually successful, maybe somewhat limited to what she originally thought she was going to get, but she was successful in being named a dependent. So cost may be in her favor, but who knows how much. But no, interesting case. We'll put the site up, hopefully, kind of beside the posted decision here. But yeah, that probably brings us to the end of our podcast. Hope, as I said, everyone's out there staying safe and healthy, and that hopefully we get back to more normal circumstances soon. But if I had the podcast over Zoom, Kira, I'm glad it was with you. So it was a great, great first Zoom podcast. But until next time, I'm Stuart Clark,
and I'm Kira Domratchev.
And stay safe.